work here. I'm a librarian. Thank you guys so much for coming to this Magna Carta talk with Mr. Steve Koch. I'm going to turn it over to him in just a moment, but I wanted to let you guys know about some other programming that we have going on. So on Tuesday, we have Cody Purcell and Spencer Girk coming in to talk about living with wildlife, and that'll be at 2 o'clock on August the 26th. They're very wonderful. They're going to be talking about bear aware and bear wise, just basically how to live with the local wildlife without hurting them or hurting us, right? And then...
Does that include humans?
I think so. I hope so. That's what I've been looking forward to. Yeah. So on August 28th, which is that next Thursday, we have a music bingo at the Mountain Merman Brewing Company. It's 90s, so we're working on, getting to the last parts of our generations because we brought them back. So thank you guys so much. I'm going to turn it over.
Whose generation, Jamie?
Yeah, come on. Look at our hair. Look at our hair.
We did start with 50s. So we did 50s, 60s, 70s, 80s, and now we're at 90s. So during the summers, we like to get a little crazy. All right, well, I'm going to turn it over to Mr. Cook. Thank you guys so much.
Thank you, Jamie.
Thank you, Jamie.
Thanks.
Thank you for coming. This is, as I've told a few people here, this is something I started as kind of a pre-retirement hobby to keep my gray matter going. And my wife and I, the 800th anniversary of Magna Carta's coming into existence was 10 years ago. And we went over with the American Bar Association. We were able to participate in some events at Runnymede with Prince William and other people. It was a spectacular event, so it's kind of kept me going. Feel free to ask questions. I've got my clock going here so I don't run over too far, but I always have too many slides on talks because there's so much, so much in my brain that I think people should hear about. But in any event, feel free to ask questions and I'll try and manage my time. The talk's really going to be 3 parts, even though there's 4 slides here, 4 bullets here. The first one is just some basics, and I used to call that what we learned in middle school, and not many of us remember what we learned in middle school. So the basics part is what they probably told us, and maybe we've forgotten, and in my opinion, there's some other things they should have told us, which they never did. The middle 2 is really history. I'm going to start with the Battle of Hastings, William the Conqueror, and talk about what happened in English law in the era of the Normans from William up to King John. And then I'll talk about his failings, King John's failings, which led to Magna Carta. And then the last third, or maybe a little more than third, will be what is in Magna Carta and show the strong correlation in Magna Carta to our laws. And I'm not saying if a lawyer might say, well, you can't say that there's a strong tie. I'm not saying that I can show this part of Magna Carta led directly to our laws. But what I am saying is that the civilization requires certain basic necessities from their government. They weren't getting them from King John, and led to, and his 2 prior, in the 2 Henrys that were before him, and that led to a group of clauses in Magna Carta that directly correlate to what we got here from our founders. And I think that's a learning that it's not just somebody wrote these laws down and we just have to write the same. It's what people want in their socialization and their civilization. So we start with the basics. Some simple questions. You don't have to answer them. I won't ask you to raise hands. The term Magna Carta has always been used. You might think it's true, but it's false. In that era, whenever a king did something, it was referred to as a charter. Well, after a while, there are lots of charters, and you have to start adding names. So these are some of the terms that over the years have been used to refer to Magna Carta, and it was probably 50 to maybe 100 years when it was clearly only going to be referred to as Magna Carta, because at the time John sealed this, and we'll talk about that, there were other things that had happened before, and there were other things that were going on thereafter. The push of the development of English law in that narrow window of time really required a specific term to be used for this document and others at the time. This is a picture of him sealing it, and this dates back to about 100 years, 110 years. It's very, very commonly seen in history books and in textbooks. And you'll see he doesn't look too happy, and that's right, he should have been drafted because he got to Magna Carta solely because of his failings. So that a lot of the pictures in history books aren't really accurate. I'll show you one a little bit that isn't, but this one is pretty accurate. Magna Carta dates to June 15th. That's what they always told us, right? Well, that's sort of true. What really happened was the terms were finalized on the 15th, but this was a big deal, and it wasn't clear that John was going to agree to it, and so they said, as best as historians know, they sat around for 4 days, all still at Runnymede, and then finally it was finalized on the 19th.
Okay, you need to correct that, it's 2015.
Oh, you're right. You're right. I could do that now, but you know how many times I go through these things. It was signed by King John. We always told that, right? False. It wasn't signed by anybody. Back then, the only thing that was ever done was the king would seal it. And there really wouldn't be seals from anybody else. I don't have this picture, but if you look at pictures online of Magna Carta, you'll see the language in the middle, and you'll see around the boundary all these seals that are from the barons who were there. That's just a historical fiction that was created for decoration in history books. He had his seal attached, and that made it come into force. The barons didn't do anything, and none of them signed it. And here's the picture I was talking about. It's about 150, maybe a little more years old, and it shows him signing it. Well, again, it's a good-looking picture, and there's some truth to it. These guys were the barons that were fighting him, and he had lost. At this time, these barons had taken over London. He wasn't even in charge of the capital of England. These are his friends, and this is probably Archbishop Stephen Langton, whose name will come up again a little later. He had a big hand in the drafting of this. But there was no signing of it at any time. And they said, oh, this happened at Runnymede. Well, that's true, but they also told it was an island in the Thames. And that's questionable, probably not. Runnymede comes from the Old English run e med, which means meadow on the council island. And you can see how those words put together end up with Runnymede. But there's Old English, just like modern English, has a variety of languages you can use. Runeg and med. That's not much different, but it's a meeting meadow. Why did they meet that there? This is a historic place in English history. It had been used as of 1215. It had been used for probably at least 600 years by the Anglo-Saxon kings. Prior to King Alfred bringing England together, there were a lot of mini kingdoms, and this is where they went to solve the problems between the very many kingdoms. And at the bottom of Magna Carta is in Latin, it's Runnymede between Windsor and Staines. And Windsor is west of London, Staines is southwest of London, and Runnymede right in the middle there. Here's what this area of Runnymede looks like. Again, it was southwest of London. This is here now called Runnymede. This is all National Trust land in the UK. Okay, Long Med was here. The memorials to Magna Carta are in this area. There is a Magna Carta island, but it really is more believed that all this happened down here. There's a tree here that's 2,000 years old, right next to the ruins of this priory. And we're lucky that it's still here. About 60 years ago, a developer wanted to put a mall here, and the English just went crazy. Actually, a little more than 60, about 75. And the English said, no, this is going to save. We're going to save this. And they did save it in the early 1950s. And the very first memorial to Magna Carta was put here by the American Bar Association. Until 2015, there wasn't anything else here. There are now several other memorials that were put in as part of the 800th anniversary. The total acreage here is about 288 acres. But we're lucky we still have it. Now, here's one they never told us. They just said Magna Carta. It's a great document. Don't forget that. Well, you would think it never changed. Well, it changed quite a bit. In fact, there are 5 Magna Cartas. I was just reading something yesterday. Somebody suggested 6, but I don't think that's accurate. Well, this part of history was a really complicated time. King John had really had a lot of problems in the 17 years he was king. And he had the Magna Carta started in 1215 because he had just too many problems with his barons. And the French were going to invade England, and he had to get everybody together to fight that war. That's fundamentally the reason that we had one in 1215. But he died less than 9 months after he sealed. It was sealed. And his son, who became Henry III about 10 years later, was still then only 11 or 12 years old. And so Henry III, John had named this gentleman named William Marshall to be the regent. And he was able to essentially take the crown responsibilities, and he knew that if they didn't do something, that the barons would go back to try and take over England, the barons that were fighting against John. And so he reissued it to keep the peace that John had tried to establish. And then Henry, the regent, his name was William Marshall, he actually was on to win the war with France, and Prince Louis, who became King Henry VI, I think, in England.
Just wondering if these barons, did they all have an army or
all of the barons would have their own, call it militia.
Yeah.
And that was a responsibility they had to have under long-standing Anglo-Saxon law and Norman law.
Okay.
So in 1217, William Marshall wins the war, and he reissues it again to continue to reinforce the beginning of an establishment of law. And then Henry III finally becomes of age in 1225. And, he's a new king. What do the kings do in this era? They go to war. They need money to go to war, so he wanted a war tax. So he said, I'll reissue it if you will, let me change this so I can get a little more money. Just like kind of our day, isn't it? And in 1297, his son, Edward I, reissued it, also with a new tax, but not really much of a new tax. And that's when it actually became part of English law, and that's the last version. What I read was somebody said that Edward first did that also in 1300. I've only seen that written one place. Were they all identical? No, they weren't. The first one was the longest because not only was it establishing some laws, but it was also settling the war with the barons. So there were a lot of treaty terms. Well, once that was issued, they didn't need to repeat the treaty terms. So about 20, 25, you can see the difference, 23 or more, went away. And then when William Marshall reissued it here, he said he kept 40 clauses and he put there's a caveat, big caveat clause at the end that says, basically it says, there's some other clauses we're not including because we need to talk about them and sort out what we really want. And that caveat clause they got this one signed. A year later, they added 3, and I think they took a couple out and then added replacements to those as well. And then down here, it's much more of the same. And the differences are very often dealing with, well, first the treaty, and then there's some clauses about debts, and how you handled lenders, the relationship with lenders, pretty controversial. With one exception, none of the judicial clauses ever left. They stayed all the way through. And the force of law since 1215. Well, it was sort of, it's really first force of law in 1297 is when he incorporated into the rules of law. Back then, keep in mind this is before printing press, so there weren't bound documents of laws back then. So the rules of law were parchment that were rolled up, and that was the law back then. And an interlude on this is where I want to make a point about the common law. All of these kings prior to this time and after this time, they wrote charters and oaths and writs and assizes and the like. And they were roughly the law of the land, but there wasn't a printing press. So, when it was first issued, Magna Carta was just the same. So when did the common law start? Well, think about, if you're a lawyer now, or if you're a judge, you and your clerks, you go figure out what the law is in the statute books and what other judges have decided, and that's what you decide, or that's what you argue the judge in front of you should decide. And that's the precedential nature of our legal system. But if you don't have all those books, you've got to have somebody around that kind of keeps track of it. And so in that era, under Henry I and Henry II, the legal system in England began in the sense of they started to have experts that knew the laws as they were in the rules of law and knew what other judges had done and said. And that's the beginning of the common understanding of what the legal system was there, or the common law. When I was in law school, there was not really a debate, but I remember reading, when did the common law start? I think it's pretty straightforward. Until Henry I, you didn't really have many rules of law. And then it had to have something that pulled it all together. And so the answer to the question, common law is about 1125. Only 3 Magna Carta terms are still in force in England. Well, that's true and false. We'll get to it, but it's like the example I use. We have laws for stealing and all kinds of things on the books. Okay, if they rewrite that and put it back in, that doesn't mean we don't have. That doesn't mean we changed the entire law. We just revised it. Well, the terms that are in Magna Carta are still part of our law, and they're still part of English law, but they're just represented differently. I don't think that means Magna Carta is not in force in England. I think that's a falsehood. The road to John becoming king. This is a lot of history, and history is a funny thing. There are a million dozens of options of other things that could have happened to avoid John getting king, but none of them happened. We'll start here. William the Conqueror, interestingly, if you see something, William the Bastard, that was his referred to name back then, because his father, he was illegitimate from his father, and his only son was also illegitimate, which led to some problems. Oh no, that's Richard down here, sorry. And so this is this is step 1, 2, 3, 4, and 5 getting to John. But you can see if William's first son had lived, who died young, we would have gone a different path. William II, he lived, but he didn't have any children, a different path. And you can say going down through here, all the people in red were one king at one point in time or another. And virtually all of them, anything that happened different with John wouldn't have been where he was. So let's start with the Battle of Hastings. You know, Harold Hardrada, who was the last Anglo-Saxon king, he's really gotten kind of a bad deal in history. He did a spectacular job getting his army to go all the way to the northeast of England and once and for all beat the Vikings at the Battle of Stamford Bridge. And if you hear Stamford Bridge referred to in England a lot, it's a big deal there, what he did. Unfortunately for him, he had to move from one end of England to the other in less than a month. And think of the era and how they moved back then. He had to get down to the very southeast of England where Hastings was, and ended up losing his life and losing the battle, which left William to be crowned the king. And the result of that was that 90% of England went from Anglo-Saxon to Norman control. Virtually all the Anglo-Saxon churches were demolished in the next 20 or 30 years, and a really high death rate in the Anglo-Saxon population. And William, except for the Doomsday Book, he didn't do much. He didn't enforce any of the promises he made when he took the kingship. He still was irregularly challenged by Viking forces, nothing like 100 years earlier when they really were attacking England. And he spent 2/3 of his kingship on the continent. As a result, he didn't really do much in the way of the legal system. He maintained the prior taxation system, and he initiated the Doomsday Book. And within the past year, I've seen references to the House of Lords in England making final decisions, or judges making final decisions in active court cases, going back to the references about the property boundaries in the Doomsday Book. It's an amazing document, it really is. He did have one set of statutes when he took the kingship, and all these things are going to start looking familiar. The first one is always one faith in Christ, that's their phrase, but one church in England. All these documents are going to start with a reference to the church. Because he had invaded and won the battle, he told people they had to be faithful to him, and the people he brought over from Normandy, they had to be nice to them, basically. He was smart enough to know that King Edward the Confessor, which was about 70 years earlier, that tax stayed in force. Why they put this one in, I've never seen an explanation. I guess,
Taxation thing?
well, it might be that.
They were doing under the table out in the field.
Out in the countryside, yeah. It could well be that, yeah.
Pretty much that.
This was never before in Anglo-Saxon law. It was brought over by the Normans. And these are pretty brutal ways of...
Good Lord.
The ordeal of iron is, you get a really hot iron, and you have to hold in your hand for, I forgot how long. And then you drop it, and then they wrap your hands up, And if 3 days later, if your hands are healed, you're innocent. Well, I mean, so that doesn't do much. The wager of battle was a true Norman thing. It actually came from the German tradition, and it was brought over by, as I said, it was one of these things where you'd fight to the death. Again, the laws of King had to remain in force. And here's a beginning of a legal. You really had to have a bond if you were in charge of something and you didn't want to be in jail. And this presumably is you can't sell somebody into slavery outside of the bounds of the country. And he does forbid capital punishment. I didn't put the little positive clause on the end there. But he says, but the penalties really you're going to have, the phrase is, eyes taken out or your testicles cut off. So, maybe capital punishment is probably better.
Candy bar.
Yeah. William dies in 1087. He's only been there 21 years. He's only been in England about 4 or 5. He didn't do much to help the church be well accepted. Anglo-Saxons still were in bad shape. The Normans had all the power, and there were still challenges to his domains in Europe. So there wasn't a lot solved. The Viking challenges that the Vikings really didn't do much after Stamford Bridge. He's got 4 sons. One of them died really young. So Robert, he wanted to be Duke of Normandy because they were French, so he wanted to be back in Normandy. He got that. William Rufus becomes King of England, which was what he wanted. Henry's given money to buy land. He was nicknamed, as you can see, Beauclerc. When you get that far down in that era, you were on your own. You weren't high enough to get land. You weren't high enough to be a military general or something. You were lucky if you were going to be a bishop. Well, Robert does okay, but he really distinguished himself on a crusade. But of course, that keeps him away from both Normandy and England. William Rufus, he was a flamboyant kind of party animal. Some of the books said he was probably gay. 800 years later, how do we know? Or 1,000 years later, how do we know? But the key point is, though, it's probable that one of Henry's friends killed him, shot him in an arrow while they were out hunting. And because Robert is out of the country, Henry took the crown, and knowing, as it says, he had to do something to kind of confirm his kingship, so he issued the Charter of Liberties. And this is Henry I. And this is, there had been things before this, like William's statutes, but this is the first one that was ever issued of that significance. And again, we start with the church, and this is the first king after the victor at Battle of Hastings, and a lot of things had gone bad. So Henry tried to correct those. And he did, this is the first time you'll ever see an heir. This is an inheritance tax, but there have been increasingly high levels of taxation. And not only was there taxation, the king had to approve it, and that he took that away. This is the first time you ever saw women have rights, including widows having rights to not only their dowry, but to the land. Those are big changes in English law. Remit all pleas. This was, they got the pleas where you could go out and a plea would be to take it to the baron or the king or somebody and say, I deserve this. Well, maybe he did, maybe he didn't, but if he didn't follow the rules, and they hadn't been following the rules, so they tightened that up. There were some other heirship standards. They went back to crime compensation, which is basically back to Anglo-Saxon law. and there were a lot of Anglo-Saxon laws saying how much he had to pay for murder, robbery, whatever, all the way up and down the list. And that included murders. Forests are always, in this next 100 years that we're talking about, were always an issue because everybody liked to hunt and they liked to fish, and the kings always liked to hunt in particular, and they wanted to keep the forest for themselves. And so alternately, kings would say, you can't go in the forest, I'm making them all royal, and then in something like Henry I, he retained William's forests. So that was not very well received. Knights had to pay their traditional payment, not the extra one that William had asked for. He's trying to keep peace. He's going back to the laws of Edward. And so he was, but he's still Robert. Robert was out there, and they had 5 years of war, challenging Henry's kingship. But Henry won. He put his brother in jail for 28 years until he died, and then Henry reigned until 1135. How was he as a king? He was considered ruthless by everybody, all historians and people at the time. He knew he had to get, in addition to the Charter of Liberties, he knew he had to further strengthen his kingship. And he was fully Norman. He didn't have any Anglo-Saxon heritage. Matilda of Scotland had House of Wessex Anglo-Saxon heritage. He married her, and that brought both the Anglo-Saxon and the Norman side back for the first time, really, into the royal family and its roots. He was the first one who could speak English. He did a good job with the government, as he said. He used the Charter of Liberty, but he didn't really do anything else. He did some structural things, but not other laws. And here's really a problem he had. Well, I guess there was two problems there. One is that he only had one legitimate son, and the other problem was obvious. The problem was that son died in a boating accident in Normandy. It was actually kind of a hero thing. They were over there in Normandy on official business, and the storm came up, and the son, his name was William the Etheling, saw his sister go into the water, and so he went in after him, and they both ended up dying. So who's going to be king? Well, at that era, there's no son here, no son here. The son here has died. So you go to the firstborn woman, and she had a son, Stephen, 1135 to 1154. The problem was Matilda is out there, and Henry had never been able to get another son, legitimate, and he wasn't going to get an illegitimate son into the kingship. So he says, my daughter will do it, and she wanted to do it, and he told his barons 3 times that she was going to be his heir. Well, that wasn't going to happen back then. So Stephen takes the crown, but it leads to a 19-year war. And that war it's called the anarchy. And these quotes are from that era, a few years after that era, but the country was just absolutely falling apart in what's called the anarchy. And the sad part is, if Stephen had lived, and they won the war, he had a son, everything could have been normal, but his wife and oldest son died, and he kind of just gave up. And so he said, I'll be king until I die, and then Henry, Matilda's son, can be the king. And so that's what happened there. Henry II, he was a pretty good guy. He was smart. He was on the battlefield with his mother from about age 12, so he had battlefield experience. He was well educated, mostly in France, legally minded, competent in several languages, but not English, several languages, but not English. And as I said, he's another one of those ones that liked to hunt. That's pretty much all he did. But because of the history, he also issued a coronation charter. And again, we got the church, and there's some problems here because he's confirmed all these things which King Henry gave them. Well, the church doesn't think anybody could give them except them because they're the church. And so that's going to come back to be a problem. And you'll see right here, again, reference, I will and firmly command that the church will have these gifts, liberties, and customs. And churches don't like that back then, probably don't like it now, but any event. It was a problem in the church. So, what is King Henry? He's got to do something. So he found Becket, a lifelong friend. He was Becket and Henry II. Great movie. If you haven't seen it in a while, the beginning part of the movie is a little bit dated, but the performances by Peter O'Toole and Burton are just amazing. They were both nominated for Best Actor the same year. You had a question?
Do you think the coronation order has influence on our Father saying state, church and state should be separate?
We're gonna
Okay,
we're definitely gonna get there. Yeah. The Archbishop, now it's the head of the Church of England, but then it was just an important bishopric in England because he still had the Pope. And Henry knew he had to simplify things with the Pope, so he picked Becket. He thought he could get Becket to go along with him. They were friends, they should be able to do that. And so he names Becket Archbishop. And he also writes these constitutions of Clarendon, as you can do. He's trying to define this relationship with the church, to simplify the relationship with the Pope. But he also, the second bullet there, attempted to draw permission of the crown before leaving the country. So you're going to tell a priest or the archbishop they can't go see the Pope? That's never going to sway. And somehow he got Becket to accept that for a while, and then Becket changed his mind. And he goes on exile. He excommunicates some people back in England that are friendly with Henry. Henry was not happy, and you know the story is that Henry was in France at the time. He said, "Who's going to rid me of this troublesome priest?" And 4 knights heard that, and they went and they killed him. And it's questionable about whether he really intended that to be the case, but it happened. Henry did some good things, but he never really recovered his strength of character after that incident. This is a list. I mentioned the Constitutions of Clarendon, but there are 4 other significant documents that he established. The first one is entirely judicially oriented, and this one here, presentment, member of juries under oath, that's juries of presentment. That's the grand jury. You present your case to a jury before you go before a judge. That's the beginning of the grand jury process, which, by the way, we still have in England, doesn't it? Justice traveled to counties to assure timely justice. That hadn't happened before. And then they gave some rights to sheriffs, which are very close to the rights that our sheriffs have now. They don't have the right to enter anywhere without a warrant, but they are required to keep track of criminals, and they're required to work with the sheriff next door. So there's a lot of things here that contemplate what we do. The size of Northampton, there were more punishments, some of them harsher. The 6 judicial circuits, and the judges had to tour the circuits. if you think about our Supreme Court, you know, there's a First Circuit, Second Circuit, and, you know, something will go, in our case, to the Fifth Circuit judge, representative judge, and up until 1911, our Supreme Court justices went to their circuit and heard cases or whatever was on the docket. So this is, that 1176, that's, what, 800 years that evolution came to us. There were the size of arms. This is military, and its standards primarily as that first arrow suggests, is because the king needed an army. He didn't have, an army of England. They had militias that each of the barons had, and so he made these are establishing rights and responsibilities that his people had to have. This point here is kind of significant, though. He gave them an out if they didn't want to be doing all this kind of stuff. They could just pay them and then get rid of it, not have to have military or troops. And that did lead to something that was significant later on. This is these writs are about property rights. And in prior eras, people would make up writs and try and get rights to property that wasn't theirs. Kind of like the way people send in a deed of title and try and take our house underneath the people who actually own it. These kind of things were going on back then, and so this is really the first structured time where we had a beginning of property law rights. He did a bunch of other things. The last point, 5 justices were appointed to remain in Westminster for appeals, and that's a directly result of Court of King's Bench, which in our case would be like the Supreme Court. But he has to go away sometime. Now he had 5 children, 5 sons, and so that should have been fine. The problem was, for the last 30 years of his life, Eleanor of Aquitaine, another great movie you need to see with, I can't think of her name, Lion in Winter, Peter O'Toole again, and Katharine Hepburn and Anthony Hopkins. And she, very strong-willed, to the extent where he had her locked in a castle for like 25 years or something. And Henry, Richard, and Geoffrey all were fighting, were on Eleanor's side. They wanted to get him out of the crown so that one of them could be king. Well, it didn't work until he died a natural death. Something. So who's going to see it? The first one died young, so he's out. Henry the young king dies from dysentery in 1183. Geoffrey dies from tournament. They really did have jousting tournaments back then, and he died in one of them right before Henry died. So Richard and John are left. But you would think it would just go to Richard, right? Well, it will, but this tells you what the family relationship is like. God grant that I may not die until I have my revenge on you. What a family, huh?
Reality TV got nothing on this.
That's right. It was not to be. Henry died in 1189. King Richard was crowned in Westminster. He lets his mother out of captivity. And he gave 3 oaths. He didn't do anything else right at that time. Bear peace, honor, and reverence to the church. There'll be justice, and we'll get rid of the bad laws. And then he went off. He went off on another crusade. He was only in England for 1 year of his entire kingship. But he was kind of successful. He made peace with Philip II. He still had to deal with John. John wasn't anybody yet. He gave him a Norman title and he gave him some lands, but he didn't like them either.
Isn't this the John from
cartoons,
Robin
Robin Hood.
Yeah, I used to include a clip from the original Robin Hood movie in this. It is that John, but you know, there are Hollywood, if you remember that movie, at the end of that movie, Robin Hood's there. Robin Hood probably, if he existed, was a couple hundred years later. And then, so John and Richard the Lionheart, King Richard, are both there. Well, John doesn't become king until Richard is dead, so that scene is a little bit, but you're right, that's the John. And I think Richard was right, never to trust him based on what happened thereafter. And unfortunately, Richard, coming back from the crusade, there's a lot of things there. He was coming back and he got captured, and John had to find some money to get Richard out of hock, basically, and then there was another battle and he died. So there's all kinds of history that we don't have time to go over. So there we are, we're down to John, with one exception. When he died, Geoffrey was also dead, but he had a son, and according, that's who would be next. He wouldn't go to John, he would go to the child of the elder son. So what happens? John takes the throne, is quickly coronated, and then, he's a good guy, just like the rest of them. He had his nephew murdered, allegedly, and he jailed his sister, Eleanor, until she died, I guess, so she couldn't have any more children. So, these guys, so that's King John. What did he do that led to Magna Carta?
So it's kind of funny how they're making these laws about murder, but they're doing it themselves and it's okay.
Yeah, exactly.
So I mean, put it mainstream.
The laws do not apply to the king back
Laws by
then.
convenience, of convenience, I reckon.
That's not right.
Sounds weird.
Yeah. So what did John do? We know now that, it's fortuitous that John became king. We've already seen that he wasn't a very good guy. So how did he do? He was at war with France right away. Now, when he got the kingship, in addition to England, this whole area was part of the English crown. And that was the result of Henry II marrying Eleanor of Aquitaine, because that was all her land. She was dead, and so the succession goes to the English king. So, what did he do? Well, he lost the war, and when he lost that war, this is the only piece of property he had left on the continent. This is Bordeaux. It's called Gascony there. It's also called Aquitaine. So he lost, and he lost a lot. The barons weren't very happy because a lot of the barons were Norman heritage, and that was their land by succession right, not anymore. And then he had to quarrel with the Pope. And this wasn't good for him either. This Pope Innocent, came into Parliament, and he was probably the first really strong Pope consolidating kind of the Catholic Church into something that looks more like it looks today. In fact, he organized what was called the Fourth Lateran Council, and which Catholic priests came from around the world, and they reorganized it, and they changed structures. And if you remember, those of us from the 60s, Pope John the 23rd, he had a convention, they call it something different. I'm missing that name. Vatican II, yeah, Vatican II. I think the church has renamed all those for eternal reasons, but he had Vatican, and that's basically the same thing that Innocent did. And that strengthened his power. I guess it exemplified his power. He always had that power, I suppose, anyway, but it really showed what the church meant. And he led the disputes that John had with the Pope led to John's excommunication and an interdict placed on the Catholic Church throughout England. Churches were closed, you couldn't get the sacraments, you couldn't get buried in the churchyard, and that was pretty bad back then. And he also rejected John's choice for the Archbishop of Canterbury. The Pope wanted Stephen Langton, who I mentioned earlier. So what happened? He lost that one too. And then he fought the barons. Well, he lost France, he lost the Pope. He didn't have any money because he'd spent, 12, 13, 14 years fighting with people. And so they weren't happy either. He lost their land. He didn't have any money. He tried to get them he tried to tax them, and that was just too much. Magna Carta was sealed. He didn't have any choice, and he died within 9 months. Between 1215 and when he died, the only thing he was able to do was get the Pope to reject Magna Carta because the language about the church wasn't quite good enough. So that's my history. Now we're going to get into what we came here for. What is in Magna Carta? It's in one relatively long document. It's probably most in an ancient Latin. Some people say it's French. If there's any French there, it's just in parts. Normans were, of course, the French heritage. The Normans actually, the word Norman and Normandy comes from Northman because the heritage of those people were Vikings who started going to what became Normandy in about 830, 850, and they made a deal with the King of France in 911, and after 200 years of interbreeding and everything, they were just Normans from Normandy. That really had a Viking heritage. The 1215, the original version, is the one I'm going to talk about. It's interesting. I was at a legal meeting of some sort. I was probably still working, so it's been quite a few years. And we were talking about Magna Carta, and I asked somebody. I asked one of the guys who was in one of the speakers. I said, "Well, do you know which Magna Carta?" I think I asked him, did our founders have the first Magna Carta when Madison was writing the Constitution? And he said something like, "Oh, I don't know, but the first one's not relevant." And well, I've just showed you that, well, you're going to see that all of the judicial terms in the first Magna Carta were in the second one, the third one, the fourth one, and the fifth one. So I think the first one's the important one. And I don't really understand why that answer came up. And it's not like, an outline form or bullet list form. It's one long paragraph, and it's stream of consciousness. And you'll see here why I say that. The first one, of course, it starts with the church, and then there's a little bit about the individual, but then they go to inheritance rights, then they go to debtors and creditors' rights, then they go to taxation, the government rights and taxation, then we get justice down here, and you got things like commercial travel, personal travel, war inheritance, so it wasn't thought out like, we need this, and then this, and then this. It was just, it worked, but it was, I don't know what to say, we weren't there. But here I've gone through it, I've kind of characterized the Magna Carta clauses into the 63, I think makes sense, 64. And these are the key ones. You can see almost a third, more than a third, of the clauses are justice. and you have another one, 6, that's inheritance. And then you've got property rights, taxation. The creditors and debtors right is only in the first one, and not in any of the second ones. And they, this was an era of, since there were no laws, then, you had all kinds of lenders out there who were doing anything. And so it explicitly referenced the Jews and other lenders. It's not just lenders, it's the Jews and other lenders. So you get another, indication of the sensitivity about people and who they are and what they do back then hasn't changed. The first one, a lot of words, look at the red. English church will be free, rights undiminished. This should have been all right, but here's, we granted and confirmed by charter the freedom of the church's elections. And then he says this causes to be good. Well, Pope Innocent backed out of that somehow. And the English church again shall be free. That command, I think the command is the part here. But it starts with the church. And keep in mind, keep in mind, this is, we've been talking about the problems with the church, but it's continues through, it's 350 more years past before Henry VIII says, okay, it's my church, and those guys can leave. So this conflict between the power and the rights of the church and the power and the rights of the monarchy is long-standing and continues for many years thereafter. And Henry VIII, he had his trouble, just like with Becket, he had his trouble with Sir Thomas More.
It's going to sound like a simple question, but were the churches back then, were they taxed? Or did they issue taxes? Were they not?
There probably was a tithing back then. Well, there was, I haven't really emphasized that. Some of the there were some monetary relationship involved, but it's a little bit complicated, and it wasn't as significant as some of the other problems that the kings had.
So they could be based on situations.
Right.
Okay.
So, but this document being what it is, after all the years, it's an attempt. This is kind of a leap for me. I'm kind of taking a step, but if I look at all of this, and I think what our founders did for us, I think it's pretty fair to say that that's where this comes from. And Madison, one of Madison's quotes is the purpose of separation of, and Madison wrote the Constitution. Jefferson and Adams. Adams was ambassador to London, Jefferson was in Paris, ambassador. And so the big writer of the Constitution was Madison. He said, the purpose of separation of church and state is to keep forever from these shores the ceaseless strife that has soaked the soil of Europe in blood for centuries. I mean, he wrote the document. I don't think there's any argument about that.
That doesn't appear in the Constitution.
It doesn't appear in the Constitution, and Jefferson and Adams thereafter do talk about that. And what they say is that it wasn't put in there because they didn't want, as a lawyer, if that phrase had been there, all of our courts would have been saying, this is what this means, this is what that means. They would have been parsing it. They didn't want 6 words to be parsed. They wanted the whole document to reflect a governmental structure that would be harder to challenge. It's being challenged now, as we all know, I think. But that's why no such phrase as separation of church and state was put in the Constitution. It's my opinion. I think that's right. Anything I've read by the founders. So I'm gonna go through some slides, and we're gonna go through some clauses, just like I did that one, and then I'm gonna try and correlate it to a concept that we're more familiar with. And some of them, I don't think this last one, church and state separation, is really a big leap. Some of them might be more, some of them might be less, but you can debate that. Here is, these clauses again, they're all over the place in terms of where they've applied, where they've sat in the document. And they all look like they have different things involved. Well, they're granting free men all the liberties given below. So everything else is being granted to all these people. Free men was about 1/7 of England at the time. If you weren't a free man, then you had some ownership responsibility to a baron. You had to respond to his rights, and free men almost always had some land of their own. And the very last one, 60, is right towards the end. Let's say this says let all men. It doesn't say free men. I think that's probably just a mistake. There's no other indication in Magna Carta or subsequent documents that suggested for another about 100 years, I think, that they were talking about all men. They were talking about free men. But it is a kind of a different clause there. It conflicts with 1.1. So merchants may enter and leave England. They can travel for business. And the prior King John and some of the prior kings had required permission to leave the country for any reason. And the 6 dots there, what I have not included, there are caveats. If they're at war with somebody, we're not going to let you go there, and that kind of a caveat. But here they're saying, if you got business, go for it. And they're also saying here, travel, not on business. Now, why would they say that? I mean, people didn't take vacations back then like we do. But if you think about it, there were a lot of Normans. The Normans had family in northern France, and at least that, and there were actually, some of the Anglo-Saxons probably had some relatives in what is now Denmark and northwestern Germany. But there has to be something there that led to this being included. It must not have been very important, because this is one of the clauses that is not in any of the subsequent Magna Cartas. Fish weirs, and back to the end of forests. The inability of people to hunt and fish to get food for their families was really a problem or a controversial situation. So these fish weirs were put in the rivers, keep the fish in a certain place, so the king could make sure he'd be able to catch trout or whatever, or he'd be able to shoot a good elk or deer, whatever it was. But so they're saying we're taking out the weirs, and we're going to the forests that have been created go back to being public domain. There are still some royal forests, but the ones that had not been royal and had been limited in access, then they go back to their historic status. And the riverbanks is the same kind of thing as the weirs. So, what does all this add up to? Where people could do what they wanted, they were given a lot of rights. They could travel, they could sell, they could go hunt, they could go fish. I think that's one of the concepts that we were not getting in Boston, when we couldn't even drink tea without paying an inordinate tax on it. I think, that's some of this stuff you have really think about, but I think that's a reasonable interpretation of what Magna Carta was trying to get back to. A lot of the things that they've been able to do 75, 100, 200 years earlier before the Normans have gotten there. This is a phrase, of course, from Jefferson. But most of the experts that I've read seem to think that Jefferson wanted his phrase, I wrote down, a broad interpretation of his phrase to allow freedom of professions, commerce, and personal goals. Well, that's kind of what those six things back here are. Professions, commerce, and personal goals. Here are some 3 different inheritance rights. So you can see there's a lot of inheritance rights, private property rights, and governmental powers. They don't even seem to look like they belong together. A lot of words here, but basically it just says that if somebody dies, the traditional tax is all you got to be able to pay for your heir to get the property. And virtually all of the other inheritance clauses are about that kind of thing. They had been overtaxed in their mind when they were inheriting property from their deceased parent. Here's 3. Nope. First one is you can't take corn, which is wheat really in our language, or other movable goods without a payment. Makes sense. You can't take his horse or his carts without his consent. And you can't take his wood from his wood pile for the castle for any other purpose without his consent. Now, when I first read this, it's one of those things where nobody talks, these are clauses that nobody talks about. You always want to talk about habeas corpus and the legal ones, but these other ones have meaning too. So why are these in Magna Carta? This is a 42-day period in the year 1207 of King John's travels. 3-day, and this you can see he's gone all these different places in these 42 days. And if it's only 5 or 10 miles apart, that's one thing. This is hard to read. This is Birmingham. This is London. This is Bristol, and this is the South Coast. Again, he's not on a train, or he's not on a Porsche or anything. This is the first 3 days, day 4, day 5, 6, and then he gets to London for a couple of days, and he goes down here, and here, and here, and here. And by the end of this, I think he ends up right here. In 42 days. I don't think I would want to do that in 42 days today. And so these guys were mad that he was always running around, taking their wood, taking their horses, taking their food. I'd be mad. I've not seen anybody else describe that, but I think that's accurate. Governmental powers, and this kind of ties into that. In addition, if John wanted to go somewhere, he forced somebody to build a bridge over the river. And so they went back, you don't have to build a bridge unless you had an ancient obligation. If you were living on a piece of property that had always been a place where people crossed the river, maybe there was a toll, that's fine, you had to keep that bridge going, but you didn't have to build one if John wanted to turn left instead of turn right. And the same thing, each of the county 100 Wapentake writings, those are all different boundaries of cities, towns, and the like used at the time. And the ancient taxes that they paid were the ones that were the only one they had to pay. And keep in mind that London at this time is probably 1,500 years old. It's much older than any of the kingdoms, and certainly much older than England. And it had all its own rules, it had its own taxes, it had its own statutes for property and everything else. And they had to give London a grant to maintain their historic rights. So we got three different categories, and I think King John had arbitrarily exercised his authority too much for these people. You know, he took away their food, their horses, made them, just too much. That's, again, that maybe they would have put the language difference, but in our language, I think he pushed too far, and people were pushing back on what he was trying to do with his authority. Now here's some taxation clauses. An aid is basically, if I'm a baron and I have people below me, I have to give them, I have to make sure they're doing what they're supposed to do for me on the land that I've granted to them. But as part of that, I can tax them, and that was what an aid was. A knight's fee in 16 and a castle guard in 29. These are the fees that the baron could require payment for to ensure that his castle was being kept up and was being defended. And again, they were increasing those fees over the years. But again, they're basically a taxation. And that's what those three, I think, are. Taxation power that was exercised back then was being used too much. Keep in mind, there was a 10-year period when, after John lost his war in Europe, he was taxing the barons because he didn't have any other money. A scutage or age, same kind of thing. Two different kinds of taxes. This is the first time that we'll receive without its general consent. And the one on the right is how that general consent is obtained. Now this clause 14 didn't last in the later ones, but there is evidence in the readings I've done that there was, not for an aid, but for a scutage, the difference being aid being on the people within a baron's estate, and the scutage being more of a general tax. And there is evidence in the record that even though this 14 didn't continue on, it was still present in the operation of the law post this time. So taxation consent, which is again what our revolution was about. So taxation power is limited and requires consent. Those previous clauses address that point. So justice. 22 clauses, as I said, a bit more than a third of the entire document. A broad range of clauses that you'll see subjects. And I think that it's hard to argue that they don't have a strong thread consistent with our laws today. Here's the first four. You can see only fined by their equals. Now, earls and barons can only find by their equals, but and that's not part today. Everybody's fined by their equals in theory, and in proportion to the gravity of their offense, we have that. 22 is a little hard to understand, but it basically says that to the extent that a priest or a clerk, a monk, has private property that's not part of his ecclesiastical role, then the same taxation rules apply to him. And then 60 is the counter to 21, all men of the kingdom, similarly in relationship to their own men.
Isn't that kind of like what they say in the Koch about all men created equal?
Yeah, it is. Only it's the same concept, but in this particular clause, it's kind of limited to this taxation area, or this judicial area, I should say.
Obviously, we not saw the similarity in their relation with their own men.
Yeah.
Oh, their own men, so, okay, I get it.
Yeah.
Well, it kind of seems like it's a
Yeah, it is. It's right.
beginning.
The last point, 61, stays in, but is, subject to the same rules. It's hard to say that really is followed much. But they're trying to say that the laws of the realm apply to all. The barons, the earls, the lay people, clergy, or laymen, all men of the kingdom. Now, that's kind of where all men are equal
Well,
in regards to the
kind of
laws of the realm.
beginning of it.
Yeah, exactly.
Clearly,
Here's-
not the-
Here's one that, we could take this one straight out and put it in our laws. It's almost clearer here than it is in our Constitution. To no one will we sell, to no one deny or delay right of justice. I mean, that's due process, as clearly stated as you can state it. And this one's another familiar clause. Nothing shall be paid for an issue of the writ of inquisition of life or limbs. This is, I'll just tell you, this is habeas corpus. But the interesting thing is, of course, this document was written in Latin. And in the Latin, habeas corpus doesn't show up. I've looked at the original Latin. It doesn't show up. So how it was correlated to, I don't know why, but the Latin phrase is not in this document. And we've all heard about how habeas corpus derives from Magna Carta. And it probably does in the sense of being a fundamental concept of law. But if you go back to the Old Testament, one of my references went back this far, and the Acts of the Apostles seems to me unreasonable to send a prisoner without telling him what the crime has been done. That's habeas corpus. Habeas corpus, you can't have the body if you don't have a crime.
Sorry, that actually is the New Testament.
Yeah.
Book of Acts.
Is that New? Sorry.
Yeah, New
Yeah,
Testament.
sorry. You're right. Right there. Yeah. Two corrections. That's for you two.
We're on the front row.
Thank you. And then Sir Edward Koch is he was probably the first, he was amongst the first 2 or 3 serious legal scholars in England. I think he was in the 1600s. And he went back to some Roman work. And then the Romans had England from 30 BC to about 510. And this is another statement of the same thing. So our habeas corpus probably comes from Magna Carta, but it didn't start at Magna Carta. I think there were some threads in the law before that. Yeah, and this is the writ called procedure. It's a writ back then. But I mentioned before, people would fake these and try and grab onto property that wasn't theirs. And so they're really saying that it has to be a writ, and it has to be sufficient to establish a right to trial in the Lord's court, the Lords of whoever had the right to the land from the king. And that's one of the first right to trial kind of concepts that have been stated in English law. And as I mentioned earlier, Henry I had grand juries. Henry II had some right to trials. It was included here as well in the card. You need to have credible witnesses, so fair trial. You got to be able to establish it with credible statement of fact. Except by the lawful judgment of the equals or by the law of the land. And the trial by jury appeared, that's the first time that Henry had the grand jury, but he didn't say once peers, and it didn't really say, credible witnesses either. We were going there, but it wasn't written. This is another one that didn't show up in any of the subsequent Magna Cartas. The men who had to do, those listed, had to know the law of the realm. They basically had to have some legal knowledge. We don't really have that in our concepts, although most people are. The judges certainly do have to have a legal background. But our government officials don't, our sheriffs don't necessarily, although they should, constables. So but that one did not make it. I think probably a lot of reasons, but one is that, getting back to my comment on the common law, there were probably such a small group of people who had that knowledge that granting them to be the only people qualified for these roles was probably just too dangerous for the subsequent operation of the government and the king. And there, throughout history, there was some local courts, and then ones that went at the court of the baron or the king. And so we're starting to establish, there are some royal courts and there are some local courts, and local, it used to be that you'd have to find the judge wherever he was to get to the royal court, and now you don't. You stay there. And these are all about inheritance and property. We've got a special county court, just like we have now. And then the judges travel around the county several times a year to get this stuff done. And as I said earlier, that was how things worked in this country until the beginning of the 20th century. All the courts here, as we're saying, have their own jurisdictional limitations. We have probate courts, we have tax courts, we have civil courts, we have criminal courts. And here, proportion to the degree of offense, serious offense correspondingly, and fines shall be imposed except by the assessment on the oath of reputable people. Limitations on penalties imposed by courts.
So it's almost like that they came about with Trump up in New York where they said the fine was too much,
Yeah.
but they found him liable.
That's right.
Isn't that statement comes in there?
It's that right. I think that's a reasonable example today.
Yeah.
They just said this is too much money, but they all said that they supported everything else.
Yeah.
And then I left this one in, but I mentioned that most of the treaty clauses didn't last long, but this is one that's sort of treaty, maybe not treaty. But there's been a lot of bad things happening in the past prior to Magna Carta, and here's a clause trying to wrong those recent lights. Wrong the recent wrongs by giving people their rights back in their lands or castles. And that one obviously didn't pass on because it presumably will solve that problem. Here's again a lot of work, but you'll see that there's a majority judgment of the 25 barons together with Stephen, the archbishop. This is the first time that we see a reference to some group acting like an appeals court. And this one does not last into the other Magna Cartas either. Some people think this is the beginning of Parliament. It's not really. And the more significant question really is, why would John, he's got to accept everything else. Why would he submit his power to 25 barons? And he doesn't have any idea what they would do. And I just, within the last couple of weeks, I just saw and read something. The 25 barons are separately listed in this document. And I went through, I did math trying to figure out where these barons came from. It turns out, reading just within the last 2 weeks, all 25 of those barons were John's friends. So, I can see him agreeing to that. They may turn on him, but I did not know that literally within the last 2 weeks. Correcting for Pastor on. Well, yeah, maybe you would or not. And here this if one of those barons has a similar suit against himself, he can't participate. Conflict of interest is, that's what we have too. So these are the rights that I've just summarized. And like I said at the beginning, I'm not arguing that any one of these clauses you can tie a string through the history of 1,000 years to get to here. But you can tie a string through the history of 1,000 years on what men and women wanted out of their government. And that's why Magna Carta is, in my mind, state law. And these are summarized in the 5 key points. But so what?
Well, could you say that the conflict of the Magna Carta and democracy is that was developed in a monarchy, not a democracy?
Well, no, it was developed under a monarchy. But the monarchy had gone too far for too long, and so they were bringing some structure to what the monarch could do and his people could do. So, So what did Jefferson? Taxes without our consent, obstructed justice, deprived benefits and trial by jury, taking away our laws. That's what happened in Magna. That's what got Magna Carta where it was. In our Constitution, trial by jury on the left, due process, and clause 39, that's due process. Sixth Amendment, right to trial, speedy trial, impartial, and due process again on the right. And then the Fifth Amendment, can't take property without compensation.
It seems like we had a lesson just this week with the $500 million fine for company put aside based on the Eighth Amendment, which was about to
I think that's right. I mean, I don't know New York law, but the court, and I haven't read all of it. I mean, it turns out like it's a 700 one. There's hundreds of pages. I can't remember whether it's that one or not. One of the others. There have been so many court cases this weekend.
Excessive bear shall not be required, nor excessive fines to be passed, imposed, not prove unusual fine inflicted. That's the Eighth Amendment.
Yeah.
So you're just saying that you still find guilty overall of the actions, but it fines too much.
Right.
It doesn't.
That's what the New York
It's like saying I stole a
Supreme Court
kid
said.
And that's one of the slides you
And
showed.
that's right. Yeah, absolutely.
And it's interesting, our preamble of the Constitution, the first thing it puts in there in terms of why we're doing this is to promote justice,
Exactly. That's what the Magna Carta
which was the bulk of what this,
is about, yeah. So here's some quotes that come back from 10 years ago, when we were over in England. It was, damage and limitation exercised by a weak king who hadn't done anything right. And I think this is sadly what we need to be doing now. Close eye on the militia and the state and its people. This is a longer one. This is from, I get a lot of older reference documents off to the archive.org, the free archive on the internet. It's a great resource. This is from a Magna Carta scholar about 120 years ago, 110 years ago. And that's the other thing that I don't think they told us when we were talking about Magna Carta and whatever grade it was, is that if you read a lot of as much stuff as I have, the strength of Magna Carta was issued in 1215, William Marshall reissued it in 1216, reissued it in 1217. And although there were a couple more after that, it got into the public consciousness that this is the way the world is supposed to work in our country. And it wasn't part of the law, it was his charter. A subsequent king could have completely thrown it out if he wanted to. It might have been a big problem, but he could have done that. But what stopped them from doing that is that everybody thought these were the rules of the road for English law and their life. And it stayed that way until it got in the rules of the law, the roles of law, And over the years, the reason people say there's only one or two or three that are now in English law is because they took these like the due process clause. It's part of a statute now. Well, just because it's part of a statute doesn't say to me that it's not part of Magna Carta. It's been relevant. It was relevant enough that it stayed around for 400 or 500 years until the English had their Statute of Right and then their own Bill of Rights. And all these things became part of their statutes, just like they're part of our statutes, starting with the Constitution. And that's what this guy's saying here. It's in the minds of the people that this is how life had to be. And it was in the minds of the people enough that it was in the minds of our founders too. And aren't we lucky? Forget what's going on now. Aren't we lucky? Thank you for coming. Happy to take any more questions. Yeah.
One more, just curious what this was. Like you said, the main thing with Madison was, he mentioned separation of church and state, religion, whatever, and everybody else didn't. But in Article Amendment 1, it says the Congressman shall make no law respecting the statute of religion or prohibiting the freedom of religion.
Right. Well, yeah, that's right. And that's what that
Who
says
wants
is
to put the dirty over here?
If
you
you
can-
could set them
you
over
can-
here would be great, just so that I know which one to do.
you
So
can
much.
have any religious belief that you want, and Congress can't stand in the way of that. And they can't change that in any way. But the step, what Madison's referring
Right
to is
here would be great.
not only that,
Thank you so much.
Thank you for the
but
tools.
in the past in England,
Like expansion, position, all that kind of stuff.
it's, well, in England right now, the church and the state are one. And ours, we don't have the church and state in one. We have the church, or a church, or whatever church you want to follow, and we have a government. And that's, there are people who are trying to bring that together. And that's unfortunately, in my opinion.
Thank you.
My pleasure.
Travel school, though, you can see that some of those things like equal rights, management.
Yeah, well, it's, when I started getting into this, I knew there'd be a lot more there than I ever knew, we'd ever been taught.
When we have time to read it, it's like we can really get in there and dig out words.
The full picture of history is sometimes much more rewarding than just the shortened version we get in sixth grade for an hour.
Okay, right here. Thank you so much.
I'm just gonna take the plate. I'll take it back, all right?
I don't know about that.
I'll wash the plate for you, I promise.
Thank you so much, that was a very informative. I've never
My
much
pleasure.
studied Magna Carta, and I sort of glazed over.
Well, we all did, we knew it was there.
Yeah, well, not really going into the 25.
Is your husband okay?
You know, he's okay, he had a hip replacement.
Yeah,
So
I
it's
know.
very- it's a little hard.
No, I just wanted to make sure. Good.
And see where this is going.
She'll be back later this week or Saturday.
Just at the tower or sunset or something.
Yeah. When she gets here, I'll text you too, yeah.
Text me,
Yeah.
okay. Thank you.
Thanks.
That was so
Thanks,
cool.
Jamie.
Thank you, I appreciate it.
Gonna grab this. Go for it, okay.
Take as many as you want.
Well, good, that's what
All our history teachers in Texas, their first name is Koch.
So I was
Oh, yeah, that's right.
One thing.
Most of ours were too.
Yeah.
Maybe taxation too.
I remember,
They also
the auditor
enacted that
put about
to keep, for one